May I please? My lord, I beg to mention item number 7, my lord. My personal difficulty, my lord, it may be immediately reopening, my lord.
Immediate after vacation. Immediately after vacation is not possible because all the matters have been adjourned to that.
My lord.
7th, okay. Both as a representative on the prayer made by Mr. K.U. Ahmed, then counsel for the petitioner. Matters is adjourned today, just on.
May I please, Lordship, I would like to mention item 26 month. Matter may be adjourned for the day, my lord, as I have to file my lord on IA, my lord.
26.
26 month. I have to file IA, my lord.
Mr. S. Ahmed.
After vacation, my lord.
Give a date.
Item number 20, my lord. Maybe adjourned for the day, my lord. I given the my lord adjournment slip. Item number 20. 20.
Active.
20.
0.
Same order, Mr. H.R. Ahmed.
Obliged, my lord.
May I please your lordship, with the consent of the other party, I beg to mention item number 43 to 45, my lord. My lord, the learned counsel, Mr. R. Islam, suddenly went to his home due to his mother-in-law, my lord.
My lord, my please, your lordship, my lord. I am for the my lord appellant, my lord. In this case, my lord, the old case, my lord, the matter may be fixed on my lord 17, my lord.
43 to 45. 21, 22 matters are.
My lord, it may be taken up on 17, my lord. Last time also made the similar period.
Display. There is a delay in 45.
My lord.
Make it 19. Both as a representative on the prayer made by the applicant. The matters went adjourned today, just on 19.
Alia, bless you, lordship.
May I please, lordship? I beg to mention for calling one additional affidavit, my lord.
Item number 19, my lord. It will be taken in next week, my lord. Item 19.
It goes after vacation. This transfer is paid for the counsel. Mr. S. Islam, current counsel to the petitioner. Okay.
Please, your lordship. I beg to mention item number 5, my lord. I'll file an additional affidavit in that case, my lord. May I please, your lordship, I beg to mention item number 24. Lordship may kindly fix it on next week, my lord.
24.
24, my lord.
Okay, goes after vacation. Same date. Mr. Your name?
H.J. Tamuli, my lord.
H.J. Tambadi.
May I please, lordship, item number 11, may I kindly adjourn for the day.
Item 11.
Yes.
Okay. You want an adjournment? When do you want?
11 item.
When do you want?
21 days.
When you want? Next week.
It's a July. It's a July.
On the prayer made by the counsel for the petitioner. Matters was adjourned today as paid for from a list on 15/7/2026.
My lord, in my item, just I mentioned for adjournment. I will file an additional affidavit. I pray for
Which
adjournment.
item?
5. Just mentioned, my lord. I will file an additional affidavit after July, my lord, after vacation.
It goes after vacation. Same date. Mr. M.A.I. Hussain.
Highly obliged.
May it please your lordship, I beg to mention item number 3. Your lordship, unfortunately, we have misplaced
See,
that.
you'll have to wait, because this is 2019 matter.
Your lordship, we have misplaced the case file, your
Whatever is a
lordship.
good
and-
reason, but in 2019 matter, we are not adjourning.
Your lordship, we are not being able to contact the
You just
petitioner as
wait,
well.
we will not adjourn.
Yes, sir.
19 matter, we are not adjourned.
May it please your lordship. Lordship, I beg to mention item number 39, lordship. Lordship, in this case, lordship, we have not received a instruction from our client, lordship. Therefore, we did not able to file our affidavit, lordship. Kindly allow us some time, lordship.
39, this is a delay application.
Yes, lordship.
So delay application in review of 22, we are not adjourning. No, this can't be adjourned.
Lordship, any day after vacation, we will file the application.
Absolutely not. In the review petition of 22, there is a delay already. And now even after 4 years, we are seeking an adjournment. Can't be allowed. No,
Obliged, lordship. May it please your lordship. Lordship, I beg to mention item number 18, lordship.
18.
Lordship, earlier engaged counsel are no more engaged in this matter, lordship. We will file wakalat no matter, lordship. Some time may be given, lordship.
Okay. Your name?
MD A. Rahmani, lordship. A. Rahmani, lordship.
Mohammed A. Mr. A. Rahman, Learned Counsel for the Learned Counsel has entered appearance and submit that he would be filing a wakalatnama in the matter. All the respondents are represented. Attestants adjourned for the list on after vacation.
Obliged, please. May I please, I beg to mention for listing, this motion method. Yes.
So one item, my lord, actually I missed out, my lord, to be very honest, my lord. Item 27, my lord. Can it be on Friday or Monday, my lord? 27.
27,
This Friday or Monday, my lord?
make it Friday.
I'm obliged.
Chairman Sanjay Dutta and Counsel of the petition, list on signs. What's his representative?
May I please, your lordship, I beg to mention for listing, lordship.
Or a similar, your lordship.
For motion, item 1 with item 2.
May I please, your lordship.
Yes, what happened?
But I might have unfortunate accident, my disc got ruptured in the back, my lord. But please, my lord. My lord, take up item number 2 for a moment, my lord, and
Yes,
my lord, what has happened in this case is this, my lord. Their parents have admitted position is this, my lord. They have come from Bangladesh in 1964 due to religious rights and religious persecution, my lord. Therefore, my lord, on my lord, on 25/7/1964, my lord, they were been issued relief eligibility certificate, my lord. I'm just giving the brief outline, my lord, then I'll come to the points one by one, my lord. My lord, after the relief eligibility certificates were issued, my lord, they were in the, they took shelter in Chandanathpur grant, my lord, that camp which was established. If my lord is looking for the relief eligibility certificate, my lord, that my lord will find in page number, my lord,
you see that 19, 20.
my lord, 19, my lord,
20,
my lord is,
you've seen that.
my lord is in there. My lord will, on that case, my lord, I will just point out few things in the certificate that my lord is with me, my lord. My lord will see,
This was not proved in accordance with law. You.
yes, my lord,
put a notice and then it says it's not there.
yes, my
After
lord,
that you
that,
left it.
my lord,
After that, you left it there. This was not proved in accordance with law.
my lord, my lord, on that case, my lord, I will straight come to the page number, my lord. Page number, my lord, 43, my lord, where issue number 1, where it discusses it, my lord. Now, my lord, OP parties claims that, my lord, is, may I, my lord? OP parties claims that the parents came from East Pakistan, took shelter at Chandranathpur refugee camp in 1964. In this connection, OP parties exhibited 1 relief eligibility certificate, exhibit 1. As per exhibit 1, Mohit Lal Bhattacharjee, son of late Mohindra Bhattacharjee, migrated from village Deor, PS Maulavi Bazar, district Sylhet, the then East Pakistan on 25/7/1964, and 6 assistants from government. One Nandan Bhattacharjee who accompanied him, who is shown as his wife. The exhibit 1 issued by the Camp Commander Rehabilitation Center, Silchar. This exhibit was sent for the verification from the authority concerned. The report received from ADC Silchar dated 24/1/2019. In the verification report, it is stated that the name of Mohitlal Bhattacharjee have searched for the purpose of verifying the authenticity of the certificate, but the said certificates are not found in the preserved records in the district record room. Hence, the report of verifying authority dated 24/1/2019, it can be safely said that exhibit 1 was not issued by a lawful authority. My lord, I'll pause here for a moment, my lord, and so the entire issue number 1, my lord, because he only determines the issue number 1. He does not go to the issue number 2. My lord has already seen that. My lord, issue number 1, while he is determining, he is only saying this. He is basing his entire judgment on a report of 24/1/2019, my lord. That report says that this document was not available in the preserved records of the district record room. Now, my lord, the question here comes at the beginning, my lord. What are the records which were there, which were preserved in the district record room? Question 1.
That cannot be and is not a question of any relevance. You see, what happens in a suit if you go and ask for the sub-registrar office to produce the original volume? They say that this volume is not there. Then what happens? You get a negative certificate. Can you prove a negative? That what documents are there and what documents are not there?
My lord,
The question is that if your document is registered, then there is a manner of proof. If the document is lost, misplaced, can't be found, then there is a particular procedure to get that proof.
that my lord,
You give a presumption. That presumption would be in favor of the petitioner, but that can't be. The trial court has, the member for this family rightly said that the burden is on you.
my lord, if I may, my lord, to answer.
Mr. Day,
my lord.
you see this document, even if it is presumed
My lord,
to be a correct document by applying section 90,
my lord.
that it is a 30-year-old document, but this document does not help you in any way. The reason is, the first reason is the problem that the lawyer who was dealing with the matter did not know what he was dealing with, he or she was dealing with. The issue here is that relief certificate in itself does not create citizenship.
Hello.
For that, you need a declaration of citizenship
Under-
under section 51A or
Hello.
51D of the
Right.
Citizenship Act.
My lord,
Now, this relief is something you see from the document itself. What does first line say? Particulars
is
of
eligible
person-
for the
particulars of persons
migrating from
migrating
East
from
Pakistan
East Pakistan or on or after so and so,
who seeks
who seek
assistance
assistance from the government.
government, my lord.
Now, that doesn't entitle anyone to citizenship. What is required to be proved is citizenship.
Right.
That's one. Second is that there was a second process initiated. Those who were given these migration certificates, for them, the government took out steps in the second phase to have them declared as Indian citizens. So that migration itself was not enough, but supported by migration was another certificate of citizenship, which entitled the person to become a citizen of India. Declaration given under 51A and 51D.
My lord is correct.
So this part is missing here.
My lord, I appreciate what is falling from my lord, my lord. Lord, if my lord permits me, my lord, if this is my lord is correct in that the some amount of handling would have been better, my lord.
Now,
I will try to put it in different way if my lord permits me for a moment, my lord.
yes, yes.
My lord, my lord, my challenge here is this, my lord. I was thinking last night on this issue, my lord, and how to now, my lord, he is otherwise, if my lord sees that this person has been displaced for communal right. Now, if I advise the client that if he wants to go under 2019 Amendment Act, my lord, I have to show a document which shows that this person is displaced communally. Now, once my exhibit 1 is out of the picture, my lord, I do not have,
See, that has got nothing to do if the government wants to accept it.
my lord, once the tribunal has, my lord, dislodged it, my lord, then, my lord, I am, my lord, if my lord, somehow, my lord, at least, my lord, that his school certificate is also, my lord, he could not prove it by calling the headmaster, my lord, like the Molloy Church, my lord, that
School certificate was not proved.
yes, my lord, yes, my lord, school certificate, rather, my lord, the school certificate, and my lord, most, if my lord, bear with me for 1 more minute, my lord, page number 27, my lord, these people are actually, my lord, in destitute home, my lord, they are in Anathalaya. If my lord will see in annexation number 7A, page number 32 also, the notice, that also records that these people are from the Anathalaya, my lord, they were in the Anathalaya, that the central destitute home in Kasar, my lord. And they were living there. In 1978, once the father has died and the family has become destitute, they took shelter in the Anathala, that is the destitute home. That Anathala certificate was also, they could not prove it. In 1978, they took shelter. And that was summarily also rejected. Now, I understand, my lord, that I am in little difficult position because my lord will view it in a little sympathetic way, my lord.
Your mother was enlisted as a voter.
Yes, my lord.
Where is that document?
That document is in page number 29, my lord, Nandan Borcharji. But she died in the year 2007, my lord, before the matter was started. It was 2011, this matter started as a D case, my lord, doubtful voter case. Two cases were registered under, against the item number 1, the petitioner, and one case was registered under, against the, in the item number 2, the petitioner. The Mohan Borcharji, there were one case, one de-voter case, and Malloy Borcharji, there were two de-voter cases of 2011. They got convicted. That mother's document is page number 29, my lord. It was rejected because it was an after 1971 document, 1985 document, so it was rejected, my lord, summarily.
No, we don't find anything here, but since you are showing us that release certificate, you can just adjourn the matter, give you time to do whatever you also advised. Maybe we don't find anything. Because the story doesn't stick together. You say that they were in destitute home,
Hello.
but destitute home will not maintain an entire family. Because your mother is a voter, the son is a voter, four voters' names are there. So they will not be in destitute home. There is no document to show that they were in the destitute home.
That is, my lord,
Everywhere you have a roadblock.
27, my lord, page number 27, my lord, is a document issued by the destitute home, central destitute home, my lord.
Which
That
one? Page?
Page number 27, my lord, annexure number 4.
Item number?
Page number 27, my lord.
Of which item number?
Of item number 2, my lord. I'm taking item number 2, my lord.
'29.
My lord,
Page number?
27, my lord. Item number 2, my lord, that is of Mohan Borcharji, my lord. I'm Mohanlal Borcharji, my lord. This document was otherwise, my lord, I'll be candid, it was rejected by the member because it was not proved.
And doesn't make
Only on this ground, my lord.
anything, because the 1978 document.
It is 1970, they have entered on 29/12/1978 into the destitute home, my lord, as per the
We can maybe adjourn it, do whatever you ask for advice, but we don't find anything here.
my lord, please.
Mr. Fine? You're showing a release certificate.
I understood. I've seen it, brother.
Okay, both sides are presented on the prayer made by Mr. A.B. Dale and counsel for the petitioner. Matter stands adjourned today. List on. Give a date after vacation.
Large.
1 and 2 common order.
Item 3 for motion.
Madam, I'm extremely sorry, Lordship. In this case, Lordship, my file misplaced, Lordship. That is why I could not go through the record, madam. Kindly accommodate for a day, Lordship, if possible. Can it be on Friday, madam? I just took the copy of opposite party, Lordship. I have gone through that. It is a contested case, madam.
Which is represented on the prayer made by Mr. Skinner Gibbs, my counsel to the petitioner, the matter is adjourned today, list on next Monday.
Obliged.
Item 4.
Sir, I need to, Lordship may kindly go through the order dated 26/5/2026. By this order, this honorable court asked me to apply before the, during pendency of this case, before the Citizenship Amendment Act, CA authority, below. But there is some server down, no? Server down and technical difficulties, now the institution, what they call technical.
Technical issue.
Okay. Because we cannot receive the SMS. The mail.
Some time may kindly be allowed.
Item 4, both sides are represented. Counsel prayer made by Mr. Idas, Senior Counsel. For the petitioner, the matter stands adjourned today, list on due date after the taken. Thank you.
Item 6.
Back reason, Lordship. When this matter was listed on 24/3/2025, Lordship, the Lordships have noticed some spelling mistake in the cost title, Lordship, and granted liberty to file application. So accordingly, I have filed application, and this honorable has granted time to file cost title, Lordship, allowing the petition, and accordingly, I have filed the cost title, amended cost title, Lordship. Now it has come for motion stage, Lordship. It is a contested matter, Lordship. Impugn order is at page 118, Lordship. It was decided on 16/6/23, Lordship. We exhibited, Lordship, as many as 17 documents, Lordship. 17 documents, and her mother was examined, Lordship, and two official witness also examined, Lordship. Her grandfather's name appeared since 1951 NRC, Lordship. And in 1966, total is 70 total is, Lordship. 75 also exhibited, Lordship. In 1997 also, Lordship, her father.
They pass.
Oh.
That was the petitioner. Next. I find this is. Find this requisition in the article being the Secretary of the Commission of India. Saying Opinion dated page 118 of thereby declaring the petitioner the partner of whose contract in 1973 notice returnable on which date notice returnable to property the reports the period of being can be considered on receipt of the title reports. In the meantime, if the petitioner engaged also is acclaimed, he shall not be deported out of the country without order of the court. Etc. Petitioner for production of a certified copy of the order before the office of the Superintendent of Police border to be in the order to be roots of the city. This transfers.
Obliged, Lordship.
Just now.
Lordship.
It's not saying so.
There's something wrong here. We have to tell because this we did not call for the records. Records has not come. Made a mistake.
Obliged.
31st of July. Item 8.
May I please, instruction was for matter, plus occasion matter, and this is a case for rooted custodial torture matter. Because matter, I was picked up by the police matter, and inside the police station matter, I was brutally tortured. And photographs matter, case 13.
they have tried to project a different story that you tried to escape. And they.
Yes, yes.
you hit-
But my lord,
Yeah.
I have not been arrested yet. Medical certificate also. I have not been arrested, my lord, and my lord, my lord, picked up and 3 hours, my lord, I was put inside the police station, my. So, my lord, and my lord, kindly see the photographs, page 13. Immediately, my lord, at 9 p.m., my brother was called by the police and I was handed over to him, my lord. Immediately, I was admitted to the hospital.
The investigation revealed something.
But okay. On 13, my lord. My lord. Yes, yes. 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 Medical report also is there. Authorization. Before.
23 is Tuesday. It is PP or outpost?
Outpost, like, outpost.
Petrol post.
Outpost. Kamalpur, Kamalpur, under Kamalpur,
Of your report.
Karva police out.
You made, you have given a statement, it's a petrol post, is a PP or it's an outpost? Second paragraph of your.
Police out. Police outpost. Police out.
No, here it is petrol. Petrol post. Second paragraph of your report.
Considering the allegation for one point subsequently, this is a Kamalpur police case now. Also investigation, Kamalpur, yes, and they were, Kamalpur police case. So when Kamalpur police number, Kamalpur, post, outpost, Kamalpur on the.
No, no, you are reading your report.
Yes.
See the first page, the second paragraph.
Yes, sir. There is a some issues in the physical Nipen Gorwa, in charge of Urubaha petrol post.
Petrol post. It's not an outpost, petrol post.
Petrol post. I report from SP, but I will correct it from SP.
Okay, the instructions for this coming.
Item 9.
May appeal the in this case, Miller petitioner filed one additional affidavit brought on record to earlier order in this in present case before this case Miller petitioner declared foreigner Miller. And the test this order is challenged before this honorable court and honorable court granted bail Miller. Subsequently, petitioner again declared foreigner in another case Miller. And
Where is that affidavit?
I think that I have a copy Miller.
Second, it's not a affidavit. After that.
Item 10.
No, there are. My lord, imperial order at page 83. Lord.
Which page is the opinion?
My lord, page 83. An opinion dated 19/2/2026.
But
M. Ali.
M.
M. Ali.
Ali Lam, counsel for the petitioner. Let's check for the respondents. Page 83 is the opinion dated 19/2/2026. Notice for the report. Extra copies will be given. Where for bail is opposed by the learned standing person to the matters. Continue. 10 days time to take bail of rupees 5,000 to the satisfaction of Superintendent of Police Border. Which place?
Gwalpara.
Work. Response.
Obliged.
31 July.
Okay.
Item 12.
Yes, lordship opinion is at page number 40, lordship. Another two. Page number 40, lordship, 40. Order dated 31/5/2022. Yes. For Mr. A. Rahman. And also for the respondents. Page 40, opinion dated 31/5/2022. Passed by so case number so. I case number so. Five is the petitioner is declared to be a foreigner of 425 in 1971. Notice written about on Swinsky, also the report. Short of within today, the prayer for bail shall be considered on visit of the tribunal report. In the meantime, with the petitioner, namely, India Khatun is apprehended, or she shall not be deported out of the country without order of the court. Shall have collection of certified copy of the order to the Superintendent of Police Border. Obliged, your lordship. Yes, item 13.
Item 13.
This is a contested case. Opinion it is page 101. The relevant person is at 104.
Also for respondents. Opinion dated 13/9/2023. Asked by Swansea. Case number Swansea, FT number Swansea, FTD number Swansea. DN case number Swansea. Is the petitioner, the petitioner was declared to be a part of 425 in 1971. Notice. Return of allowance. So, in today's policy report. Fair property shall be considered on receipt of the travel report. In the meantime, the petitioner namely apprehended shall not be deported out of the country without order. He shall not be deported out of the country without order.
Objection.
31-7. Item 14.
May I please your lordship? Lordship, kindly take up the matter at 2, your lordship.
Item 15.
Yeah, the contested matter was. Opinion, yes, lordship, 50. The lordship delay is 2019 matter, lordship. What is the explanation of delay? Lordship, case 70, para 18, lordship. That can't be a ground. But Mr. SI Talukdar.
SI.
Talukdar. SI Talukdar, counsel for the petitioner, as also for the respondent. Opening is at page 50. Dated 30/5/2019. Asked by so-and-so in case number so-and-so, SP reference number so-and-so. By which the petitioner was declared to be a foreigner post 25/1973. Keeping the issue of maintainability open. Issue not going to inordinate delay of around 7 years in studying the opinion. Issue notice regarding law insurance, extra copies in 2 days. Confer the record. Period for bail shall be considered on the receipt of the transfer record. given the petitioner is apprehended, comma, petitioner named is so is apprehended, comma, shall not be deported out of the country without order of court. The petitioner shall cause production of a certified copy of the order before the Superintendent of Police order. This place, Congress. So coming now. This one's with some. 31 July.
Highly obliged. Item 16 for motion.
Back to the lordship. My lord, the issue in this case is, my lord, little different, my lord. This petitioner lady is a, my lord, challenging the, my lord, proceeding, my lord. He is contending that, my lord, she was never, my lord, investigated, my lord, in this matter, but without proper investigation, or, my lord, not at all, my lord, any investigation, this proceeding was started, my lord. Where, my lord, as per law, my lord, investigation is necessary, my lord. And our father's name is also not properly, my lord, mentioned in the reference point.
You will entertain only after the proceedings are over. If the proceedings have been initiated. You take the defense there.
Because, my lord, if, my lord, our, my lord, names, father's name, and, my lord,
Then
other family members, and their
then
particular,
you will be discharged. There cannot be a conviction. But we do, in this matters, we are not taking up application for rejection.
then, my lord, they will, my lord, say, my lord, that their names and father's names are not matching, my lord.
That you have to prove it there. We don't have a principle of order 7 to 11 rejection of plaint applying here.
My lord, according to, my lord, the judgment, my lord, I have, my lord, also quoted this judgment, my lord, of the full bench, 2013, my lord, 1 GLT 809, my lord, it is the basic criteria is that, my lord, it is held that, my lord, it is fundamental and human right of the person.
So that the authorities will prove there.
He is not objecting, my lord, only praying that, my lord, our case may be, my lord, investigated, my lord, and proper report may be sent.
Once it has been investigated, why you want for better investigation?
My lord, she is denying, my lord, she was never, my lord, interrogated or, my lord, approached by the police, my lord, this police.
You raised the grounds there.
You take the defense, whatever you are taking it here, you take that defense there. Which paragraph of Muslim Mandal you are relying on?
My lord, Muslim, my lord, page, my lord, paragraph 96 onwards, my lord.
Any other judgment? Yes, just.
No, there only, my lord, there, my lord, it is, yes, it is a full bench judgment, my lord, it was provided, my lord, it is, importance was given to the, my lord, investigation.
This is very premature at this stage, my lord, because if the proceeding has received notice, he has filed WS, my lord, just to prove these facts, whatever is there by leading evidence, my lord. Mere saying that no investigation was done, that will not do, my lord.
In the written statement also, she has gone into the matters of the case, barring only few
Yes,
lines
yes,
that investigation not done properly.
yes. There are two, my lord.
Only?
Yes, two.
Few lines.
Yes.
Actually, my lord, my humble understanding is that, my lord, that prosecution side, my lord, should give importance to the investigation. It will be, my lord, easier and convenient for the court and, my lord, the proceeding also, my lord. If, my lord, they are not giving, my lord, at all importance to the, my lord, investigation. But this kind of cases, my lord, investigation is, my lord, sacrosanct, my lord, as per my humble understanding, my lord.
There are two WS she has stated, my lord, that instant case has been registered and proceeded against the opposite party illegally. Which is his allegation that this is proceed illegally. The border police did not make any file visit during investigation, never asked the opposite party to produce any document for proof of any my Indian citizenship, never interrogated to the opposite party in presence of village head, and case has been falsely referred against the opposite party without giving a person to demonstrate that. This is his allegation. This is the allegation. Yes, the investigation report itself is not there. We don't know what is there in the investigation report. But apart from that, these are factual aspects. It has to be proved by them before the tribunal.
They are
No,
to, my lord,
Whether the police visited or not, whether investigation was or not, this is to be, if they are alleging that this was not done, it is their duty to prove, my lord.
whenever, my lord, any criminal trial is, my lord,
This is not
on, my lord. We have seen, my lord, when there is, my lord, any investigation is not fairly done. My allegation is that, my lord, the investigation was not at all, my lord. As per my instruction, my lord, the police did not do anything. Normally, my lord, if anybody is suspected, my lord, the police will ask her, my lord, what is your address, what is your. Yes. But. Yes, sir. D.
Constitution of India, the petitioner has prayed for calling of the records of FT case number 2496/2011 from the learned member from a foreigners tribunal number 1, Nagaon. And direct the state respondents to conduct a proper inquiry and investigation in respect of the citizenship status of the petitioner and her family members in accordance with law. The, in brief, the case of the petitioner is that upon receipt of a notice of the proceedings of FT case number 2496/2011, she had submitted a written statement containing that she's an Indian citizen and wrongly dragged to prove, dragged in the case to prove her citizenship. So the learned counsel for the petitioner has submitted that there was no proper inquiry and investigation as regards her citizenship status. It is stated that the proceeding was initiated against one lady whose name is Amina Khatun, daughter of Ozid, O-Z-I-D, Ozid Ali. And that there are many Amina Khatun in the same village. but the petitioner was never subjected to any inquiry or investigation by the concerned police to verify her citizenship status. It is submitted that the petitioner was never asked to produce any document, and therefore no inquiry whatsoever has been conducted. Full stop. Accordingly, the learned counsel for the petitioner, by placing reliance on paragraph 96(2), which section? 96(2),
96, 97, 98, Malad.
96 to 98 of the case of State of Assam versus Muslim Mandal and others, 2013, 1 GLT 809, has submitted that fair investigation and proper trial is one of the important facets of Article 21 of the Constitution of India and is required to be followed in the proceedings before the Foreigners Tribunal. Accordingly, it is submitted that the present proceedings initiated against the petitioner be stayed till the police makes further investigation, further and proper investigation in the matter. Next. The third contract of the learned stanicus for the FT and bottom matters is submitted that the burden of proof lies on the petitioner, and therefore in her defense, the petitioner can raise any plea with regard to the issue involved, the issue raised in this petition, that she is not the intended proceeding. Next. It would be relevant to quote herein below the paragraph number 96 to 98 of the case of Muslim Mandal within brackets Supra, cited by the learned counsel for the petitioner. Next, from the said part of the decision in the case of Muslim Mandal within brackets Supra, it does not lay down the law that in the event the petitioner takes a plea that the investigation was not proper, the tribunals would exercise any power or jurisdiction to reject the complaint. The next part, the tribunals are mandated by the observations made in paragraph 98 of the case of Muslim Mandal to see that the reference by the referral authority is not mechanical and that the tribunal can examine the materials produced and collected during investigation before the investigation stop. Accordingly, the tribunals are required to privacy satisfy itself with the existence of the main grounds before issuance of notice to the proceeding. Stop. However, that by itself does not give any authority to the Foreigners Tribunal to reject a complaint full stop. As per the mandate of the Foreigners Act related with Order 3 of the Foreigners Tribunal's Order of 1964, that the Foreigners Tribunals are required to answer the reference made before it. Therefore, comma, in the event the tribunals are satisfied that there are no grounds for the state to support the allegations about the proceeding being a foreigner, comma, it can return the reference against the state. Next. This court, in the case of Rukia Begum Bosnia, alias Rukia Begum versus Union of India, within bracket 2023, plus 4 GLT 1208. Has laid down that the requirement of Rule 2 within bracket 1 of the Foreigners Tribunal Order for 1964 makes it discernible that central government may, by order, refer question as to whether a person is or not a foreigner within the meaning of Foreigners Act of 1946 to a tribunal constituted for the purpose. Accordingly, it was held that on that going by the statutory provisions of clause 2 within bracket 1 of the Foreigners Tribunal Order from 1964, any reference would have to be understood to be a reference to the tribunal on the question whether the person so referred is a foreigner or not within the meaning of Foreigners Act of 1946, where again foreigner is given the meaning of a person who is not a citizen, and again where a citizen is defined under Citizenship Act, 1955. Therefore, court is of the considered opinion that as the petitioner has already filed a written statement, in the event the projections as made before, made in this petition has not been taken as a defense, it would be permissible for the petitioner to file an amended written statement and take all such plea as she may be so advised. And the Learned Foreigners Tribunal, upon doing the needful, and after examining the evidence and materials, shall pass a reasoned order. Next. Accordingly, as the tribunals, the foreigners tribunals are not vested with any power or authority for rejecting a complaint. This court, in exercise of certiorari jurisdiction under Article 226 of the Constitution Order, shall also refrain from examining the complaint at this stage when the issue has not been decided by the Learned Foreigners Tribunals, as it would amount to exercise of ordinary jurisdiction by this court. Accordingly, this petition stands closed with observations that we made here in the court. Next, the parties are left to pay their own cost. If you have not taken a plea, you can raise the plea if you are permitted. Take a short break and come back. Leave look.
Item 17.
Next, my lord. Lord, here, my lord, the reference was made, my lord, on 2004, my lord. Then case registered in 2016. Petitioner received summon in 2018, 29/6. He appeared, my lord, and filed 2 petitions, my lord, for adjournment. Third petition was rejected. An impugned order has been passed, page 36, my lord.
Very
Okay.
late time.
Page 37,
2019.
Lord. In 2021, husband died, who was taking care of the case, my lord.
No, but this is too late to come again.
This is the explanation.
My lord, explanation page, paragraph 13, my lord, I have it. 13 and 14, my lord. I'll annex the order sheet also, my lord.
But you see, this is 2019.
Lord.
Your husband died in 2021.
Even for this, digital your place and status verdict. And you wrote that.
is registered 2016. Someone received 2018. Reference of 2004.
No, but whatever be,
Lost.
After the appeal.
Lost. So one opportunity may kindly be given by.
but this is not a good explanation for 6 years of delay.
2015 3HSC must be on a different line.
That was-
That we have record, the delay will not come in delay.
That was also regarding citizenship. Madam.
Find your written statement there.
Lordship. At any terms and condition, madam.
So filing the written statement, you did not appear.
No, she appeared, my lord, filed petition for adjournment, my lord, to produce document. Order I have annexed, my lord. Is 30 and 31. Two dates, my lord. On the third occasion, it was delayed. Our elder brother was declared as not foreigner by the same tribunal.
kindly see, this is the petitioner before your lordship has given that as per his statement itself. My lord, she has come before this honorable court only when police visited to her house in the month of May 2025 to arrest her. Otherwise, she would not have come. So that is another aspect, my lord. Whether she is a brother or not, we don't know. That is the material fact which they have to prove. Secondly, my lord,
See the opinion with regard to my brother, page 26.
we are not. I'm not to comment this opinion of the brother because that aspect is not the subject matter of silence here. So I'm not commenting on this, my lord, the opinion of the page 25. However, my lord, if it is the brother, they have fight it out, my lord. They have fight it out. They contested the case, and rightly or wrongly, there may be an opinion, my lord. I'm not on the merit of the opinion. Now, if she is claiming that she is the my lord, sister of this person, and she must get the benefit of this opinion, that has to be placed before the tribunal itself. There is a different aspect, madam. Prime. My contention is that, my lord, the petitioner before your lordship, she appeared, she filed her WS, but the WS is probably not an clear witness. Page 20. Page 20. And after filing of the WS, my lord, she did not appear. And it is, she appeared, but she did not file the evidence, and later part, she did not appear. Now, my lord, it is not the case that she did not know about the proceeding. She had the knowledge. And, my lord, the submission before this court is that, my lord, the advocate did not inform. Is it the duty of the advocate to inform her? It is her case, my lord. She will have to take the initiative. And she had been sitting idly since 2018. And now when 2005, the police searched for them, my lord, searched for her to detain in deport. Only she is now coming now before this honorable court. Otherwise, she would not have come. That is the sure, my lord. And tribunal has no alternative but to declare him to be foreigner on this manner, my lord, in this manner. And what she has said, basically, 28.
Tuesday. Tuesday.
Now, if we see the WS also, my lord, what my learned friend is saying that our brother have been declared to be Indian. The brother's aspect is not there. See, in fact, if we see the opinion, my lord, of the brother, he has been declared to be Indian in 2016 itself. And this WS is filed in 2018. And there is no whisper about his brother, our brother. And that one of his brother have been declared to be Indian. Those things are not there. Now at this stage, claiming these things that my brother have been declared Indian, so I may be given opportunity. That cannot be accepted. Man. Had there been some whisper in WS, then also different aspect.
Sorry, Mr. Ali, we have to dismiss it. Heard Mr. R. Ali, learned counsel for the petitioner, and Spencer for the respondents. Let's go. By filing this petition under Article 226 of the Constitution of India, petitioner has assailed the ex parte opinion. No, sorry, the opinion dated, not ex parte, opinion dated. Page 36. Dated 26/4/2019. Passed by the learned member, Honors Tribunal, 7th Hpur at Balipara, in case number so and so, reference number so and so, dated so and so, by which the petitioner is declared to be a foreigner post 25 to 1971 stream. On failure on part of the petitioner to adduce any evidence after filing of written statement. Next. The as there is an inordinate delay in assailing the imperial opinion, on a query of the court, the learned counsel for the petitioner has submitted that the petitioner had filed a written statement on 29/6/2018, and the matter was thereafter fixed for evidence on 18/7/2018. However, on 18/7/2018, the petitioner had filed a petition for adjournment seeking some more time as the original copy of certain relevant documents could not be corrected, for which evidence could not be filed. Thereafter, the matter was fixed on 14/8/2018, and once again, the petitioner paid for some more time as the relevant documents could not be corrected. The Therefore, adjournment was allowed as an extreme last chance, fixing the next date on 26/9/2018. Once again, the petitioner paid for an adjournment, but the state Lawrence Tribunal, after rejecting the prayer for adjournment, fixed the case for argument on 9/10/2018. However, petitioner remained absent on the 9/10/2018. And the Lawrence Tribunal, after hearing the counsel for the petitioner, fixed the matter for opinion on 4/12/2018, and thereafter the fixed matter for opinion on 26/4/2019. Next, the learned counsel for the petitioner as per the same. The learned counsel engaged on behalf of the petitioner had not informed petitioner regarding last chance being given by the learned tribunal to the evidence moreover it is submitted that the husband of the petitioner was looking after the case but he died in the year 2021 due to COVID-19 pandemic. And accordingly, the petitioner could not keep a track of the case. And only when the police visited the house of the petitioner, the month of May 2023, then the petitioner could come to know about the said opinion dated 26/4/2019. Next paragraph. The learned counsel for the petitioner by relying on the case of Sam Sanmilita, SANMILITA, Mahasan, MAHA, SANGHA versus Union of India, 2015, bracket plus 3 SCC 1. Had submitted that as the issue related to deprivation of fundamental rights of citizenship and rights of citizenship, the doors of the court should not be shut out. And accordingly, it is prayed that that despite the delay in selling the said opinion, petitioner be given an opportunity to prove her case. By further relying on the decision of the Supreme Court of India in the case of Sarvanan Sonowal versus Union of India and others, within bracket 2007, bracket was 1 SCC 174. It was submitted that due care should be taken that no genuine Indian citizen is thrown out of the country. Next, by relying on the copy of opinion dated 14/6/2016, passed by the learned member from a foreigners tribunal 8, 12, Halamara, page 25. in so-and-so, that could refer some so-and-so, comma, it has been submitted that the by the said opinion dated 14/12/2016, comma, the brother of the petitioner, namely Salamuddin, Salamuddin, alias Abdul Salam, was declared to be not a foreigner by answering the reference in the negative. Accordingly, it is submitted that petitioner should be given an opportunity to prove a difference. Next. But Consul for the government standing counsel for the FT and border matters has made his submissions in support of the Indian opinion. It is submitted that the petitioner is not referred to the proceeding in order dated 14/12/2016. Passed by Swansea at page 25 to be her brother. In her written statement filed on 29/6/2018. Accordingly, comment is submitted that as there was a delay, inordinate delay in the filing of the petition, petition would not be entitled to the relief. Next. On a perusal of the opinion dated 14/12/2016, passed in the proceedings against one Salamuddin alias Abdul Salam, it is noticed that the learned tribunal had not recorded the stand of the said proceeding regarding existence of any sister. Moreover, comma, in the written statement filed by the petitioner on 29/6/2018 before the London Provincial Tribunal, it is seen that there is no statement that Salamuddin alias Abdul Salam, the proceeding in FT within bracket 8, bracket close case number 431 of 2016 was a brother. Moreover, it is seen that there is no document That no document has been filed in this petition to show the existence of the petitioner and the proceeding of FP within bracket 8 bracket was case number 431 of 2016 together. Next slide. Not this last same paragraph. Moreover, it is seen that the opinion in FP within bracket 8 bracket was case number 431 of 16 is passed on 14/12/2016. Whereas the petitioner had filed a written statement on 29/6/2018. But there is no reference to her brother. Court does not find a sufficient explanation regarding the inordinate delay. First, the statements made in the petition indicate that the opinion was opinion impugned in this petition was passed on 26/4/2019. And even if it is assumed that the husband of the petitioner was looking after the matter, but the husband of the petitioner is stated to have died in the year 2021 due to COVID-19 pandemic to interrupt service. This for the petitioner had accepted, is found to have accepted the opinion dated 26/4/2019 passed by the learned member of Ordinance Tribunal 7th Tejpur and Badipara. Without finding any challenge to the said opinion in a reasonable time thereafter. Next paragraph. Although the provisions of Limitation Act does not apply to a litigation. So, however, when there is an inordinate delay in selling the impugn opinion, well, citizenship of the petitioner was questioned, and due to non-filing of the evidence on affidavit, the opinion was rendered against the petitioner in favor of the state. The petitioner ought to assail the said opinion within a reasonable time. Full stop. Therefore, as the status of the petitioner as foreigner has attained penalty for more than 7 years after the opinion was rendered on 26/4/2019, or the court does not find any good reason for accepting for entertaining the writ petition filed at a belated stage after 7 years of the passing of the said opinion. Accordingly, the writ petition fails and sale is dismissed. There should be no orders to post. We continue post lunch.
Timing item 9.
This paragraph is a requirement that parallel proceedings were pointed out to the court. Which paragraph of your
Milord.
additional affidavit?
Additional affidavit, my lord, filed because of my lord, last occasion matter.
So where is the paragraph that two parallel proceedings were brought before the court that?
Earlier petitioner declared foreigner, my lord, a declared order put into challenge before this honorable court granted bail, my lord. Simultaneously, another proceeding going on and subsequently declared him also foreigner, my lord.
No, but in the second opinion, at
Yes.
page 74.
Yes, my lord.
We don't find a reference to your to the FT case number 6926.
Yes, my lord.
Okay, but we'll issue notice on, there can be only one opinion.
Yes, sir.
So ultimately, in the earlier case also, page 90C, we have issued an order.
Yes.
We can take both the petitions together after the receipt of records.
Yes, that will be the. What did it petition?
There cannot be only one opinion.
Yes.
Okay. But Mr. A.M. Ahmed learns from for the petitioner and also heard questions for the respondents. By filing this writ petition under Article 226 of the Constitution of India, the petitioner has assailed the opinion dated 24/3/2026, page 74, asked by so-and-so in case number so-and-so, old case number so-and-so. Police reference number so-and-so, by which the petitioner was declared to be a partner of 25/3/1971 stream. That the learned counsel for the petitioner, by referring to the additional affidavit, has submitted that by another opinion dated 26/11/2025, passed by the vice versa, page 100, passed by so-and-so and so-and-so. Petitioner was declared to be a foreigner of post 25/1971 stream. This court by an order dated 3/6/2026 has made an observation that in the additional affidavit, the petitioner is to mention whether the fact of withdrawal of the continuation of two parallel proceedings was brought to the notice of the tribunals at any point of time. Stop. Or cursory perusal. Stop. No such statement has been made in the additional affidavit. Stop. Now on a cursory perusal of the both the opinion, it does not appear that it does not appear from the set to opinion that the reference to a parallel proceeding was made before the learned ordinance tribunal. Next part, be that as it may. Issue notice, returnable on special. Return in 4 weeks, stock office within 2 days, call for the record. The prayer for bail is opposed by the learned standing counsel for the FT and border matters. Expert considering the projection, 10 days time is granted to the petitioner to take bail of rupees 5,000. The satisfaction of the police border, which place?
Goalpara.
Valpara. List also and so. After the records are received, you make a prayer, we'll tag.
Yes, ma'am.
You just say tagging of both, tagging of this writ petition with WPC 995 of 2026 shall be considered after receipt of the records. List of proposals.
Obliged.
Time being item 14.
May I please your lordship. My lord, the impugned opinion is at page 51, lordship. Initially petitioner appeared, lordship, and filed her written statement as well as evidence, but subsequently she could not appear, lordship.
What is your explanation here?
My lord, after filing the WS as well as evidence, lordship, due to lordship her ill health, lordship, and she is belonging to a very poor family, lordship. So she could not able to communicate with her council, lordship, and that's why that absent was lordship. She is absent. She was absent, lordship, for long time, lordship. So now, lordship, only one chance she may be allowed, lordship, to do, so that she may be cross-examined, lordship, because only the cross-examination part was lordship pending.
But you, what is the reason assigned here? You did not appear for 2 years.
Yes,
What
lordship.
is the reason assigned here?
Lordship, I have stated, lordship, at paragraph 11, lordship, although no documents, lordship, their lordship. Paragraph 11, I have stated, lordship.
In this case, we may consider giving an opportunity to the petitioner to appear. Here's the petitioner. She has relied on the opinion of her brother.
Yes.
He was declared to be not a foreigner. That is page 43.
Yes, mentioned, my lord, in WS, she has mentioned,
She mentioned, even the evidence she has mentioned.
yes, about the, my lord, the
Brother.
FT case. Is 21. That is admitted position, my lord, she has mentioned. However, the conduct of the petitioner, my lord, page 52, if your lordship may kindly see.
If somebody is declared to be a foreigner in her own brother, is that an opportunity?
That is stated there in page 21, my lord, in his, in her WS. That there is a case pending, that your honor, in the state footer list, in the footer list of 1997 against my brother, Sarikuddin's name also marked as B, and he also faced trial in tribunal, bill number so and got judgment in his favor. That is admitted, my lord. She has stated in her WS. Now, my lord,
She was absent.
in the question arises, my lord, if your lordship may kindly see the conduct at page 52.
No, this there. It's
Yes.
taken more than 1, 2, 3,
Lapses,
5,
lapses on the part,
8, 9, 10, 11, 12 adjournment.
yes, my lord, lapses on the part of the petitioner, which to be considered. And what his explanation is only one line, my lord. At page 8, my lord. That is the only explanation.
You understand, but she's a
Where
brother.
11, it is said, filing of her evidence, the case was
Brother has
fixed.
been declared to be an Indian.
No, that is, my lord, whether he is brother or not, that aspect has to be, established by the petitioner. If it is,
Given
that is a different issue. But my lord, the lapses on the part of the petitioner. Because what he explained, however, due to poverty, ill health, and miscommunication with her English counsel, the petitioner could not appear at the learned tribunal on some of the subsequent dates starting from 27/7/2022. And this opinion was rendered in 2024. Thereafter, my lord, he approached this honorable court now in 2026. That explanation is not there. Whereas he has been approaching this honorable court so belatedly, my lord. The opinion was rendered in 2024. 25, 26, no explanation to that fact. Not a single line. No.
Into the past. District Legal Services Authority.
Alright. Even in Abdul Quddus, my lord, it is said.
Yes.
They can be considered, but each and every case has to be looked separately, ma'am. Because one may come earlier, one may come later. And in fact, in this opinion of the brother, projected brother, my lord, Sarifuddin,
That obviously we are unable to say anything.
yes, madam, that we are not to examine this. But whether he has mentioned with regard to the brother, his spending of the projected the petitioner or not, ma'am.
No, in that day, when the written statement was filed, she has stated that brother has an opinion.
Yes, my lord,
Opinion
whether,
declared.
no, I understood, my lord, because the opinion is rendered in 6/11/2017, my lord, in case of brother. She may take the benefit. She may take that opportunity, that picking up this document, but whether the brother has somewhere mentioned. If it is mentioned, my lord, it's no case, but whether the brother has mentioned or not.
That we don't know, that will be
Well-
the fact that was taken into account.
Opine, my lord, in one case, if the tribunal may opine that he is an Indian, anybody may come and say, here's my brother and sister. And so I have to, I may also be declared to be Indian.
He's referring to the document in your written statement.
But sorry, put in one, sorry, put in bottom.
আপনার এটুক আছে এই ভোটার লিস্ট আছে সরবর্তী এটুক পজিটিভিটি আপনার
Will get them. Will get them. Here we are inclined to give an opportunity. This-
In that case, my lord, my prayer will be, let the record of both the cases may come on. We may examine that aspect. Because
And Mr. Image, over here and from. Next, Gabriel, I'll call for the petitioner and first for the respondent. But for this, provision under Article 27 of the Constitution, 26 of the Constitution, there is a petitioner, okay? The opinion dated page 51. 17/2024, passed by so and so. Police inquiry number. Service the. Petitioner will declare to be a partner for on failure to appear for cross-examination. Subsequent report. We thought for the petitioner submitted that the petitioner relies on the opinion dated 6/11/2017, which particular passed by so, by which her projected brother was declared to be a foreigner. And so the Canadian. Oh, sorry. Notice available on so and so. Including sponsor the record of page 14, page 51. Fair for page shall be considered on the side of the title of the record. In the meantime, the petitioner, namely Mohammed Nasar, is appeared shall not be reported out of the country without order before. Petitioner check on production of the certificate copy of the order before the Superintendent of Police order. History moving now. Bring the order to the list.
31 July.
File application.
Upgraded item 39 for orders.
Page visual also.
Because it was not.
Affidavit with regard to the delay is not filed.
Yes, Lordship,
Not filed.
not filed yet. So we have not received any instruction from our client, Lordship. On last
This has to
occasion,
be
I was
dismissed.
right to file affidavit regarding
Then
delay
this has to be
partnership.
dismissed.
You have filed one additional affidavit, but again on marriage.
Yes, Lordship.
But if you're not getting any information from from the petitioner, we'll have no option but to dismiss it. In your additional affidavit filed earlier, we have given the telephone number of the deponent.
Yes.
If with disclosure of that phone number, if you don't get message,
We have already communicated to the client lordship, but proper instruction was not furnished to us regarding delay per lordship.
we are adjourning till Monday. If it doesn't happen till Monday, then we'll have no option but to discuss it. But Mr.
Gauhati Moria.
Gauhati Moria, then ask for the applicant. The learned counsel for the petitioner pays for some more time to file an affidavit in terms of order dated 12/5/2026. For Angel Justice, my understanding is done today. No affidavit is filed by the next date of listing, those orders may follow. Next, list on 24/6/2026.
Item 41.
Now, kindly see the last order dated 15/12/2025, where an unregistered organization intends to, my lord, file an application for impediment, my lord. Maintainability is the issue, my lord, required to address now.
Yes, why do you want to be impeded? Like, first of all, it's not for the law, there is a local, association of women. Just nearby this. Just near the sector, the members of the association, they reside just near the sector. They want to impede and impede themselves in this case to say that they have no grievance at all. If the owners are not allowed to perform something, the tradition of the convention that has been maintained since the inception is the establishment of that sector right in our country. It's the only thing that they want to impede themselves. First of all, the second thing about this issue has been is now under the examination of the Honorable Supreme Court. You have not even said this in your application. You don't even say that you support the entry of the banning of the women in the Sabta. In your application, you don't say so. After the impediment. No. You have to demonstrate you are trying to impede yourself in this application. You have to show that you have interest here. Once you're impeded, your affidavit will be different.
Since we are not yet, we are thinking that.
No. Don't think. Because you'll have to show a reason to be there.
Well, we'll be affected party, that statements are there. We'll be affected party, otherwise, because we are interested. And if it is.
No, you see, by that you will be affected. You can't be affected because you are not going in. You see, as a woman, you say that you are happy with the situation that you are not going in. If you are not going in, how can you be affected?
They want to go in.
No, well, here's what if I may put it otherwise. Well, we are supporting and we are amenable.
That statement is not supported by your affidavit.
That is correct, but that statement is not here. We were thinking that if it is allowed to come inside the proceedings, then we'll file it.
No. Because you see, you are entering proceeding by Mr. Samaria. You have to show that you have an interest here.
And in that case, one of the lordship permission will file an additional affidavit in the IM, bringing all this to some record.
Unless you show that you will not be you will be a third party. You are not affected by this fair made.
Lordship is correct. We'll do it by filing it.
My lord, if lordship permission on last occasion, section 6, my lord.
Technically, Mr. Samaria,
My lord.
you see, number one, we can outrightly reject your application for a simple reason. Number one, you are not a devotee of that satra.
My lord.
If you are not a devotee, you are just a busybody who is trying to interfere with the religious customs.
Right.
Why should we permit
My
that?
lord, the locus is a issue that has been decided numbers of times by the Supreme Court, my lord.
But still,
In respect of PI, my lord.
but still, you are not a devotee.
My lord,
Now you see what has happened once the
my lord, how it is possible to say I am not a devotee, my lord? I am also a devotee, my lord. There is no any doubt to that effect.
You are not.
I am also the follower of my lord, same religion,
You-
same
you are
practice,
not.
my lord. The lordship
You are
can-
not, because in your statement, you have not given that you follow that procedures.
My lord,
Because
thing is
if
that,
I now tell you,
so far the locus is
I'll
concerned.
tell you, if I now ask you to recite a particular shloka of the Vaishnava ritual which is being followed, when they open the gate, they recite a mantra,
My lord,
you will not be able to say that.
my lord, locus is a issue, my lord. That is a broader terms in respect of PI.
But still, that you have to give him an opportunity.
Otherwise, they have to address section 6, my lord.
Hmm?
Otherwise, they have to address section 6 of the Society Registration Act, my lord, where lordship last occasion put a question that society which is not registered cannot come directly. It has to be followed by the mandate of section 6, which indicates that was the core issue lordship on last occasion put before the other side. Should buy and against the
File an
society.
affidavit. Let him file an affidavit.
Well,
Administrator Dr. A. Samuel and the petitioner, applicant. And Samuel and the petitioning person. Or the opposite party here. Next one. Preliminary objection was raised by the respondent in person that the applicant would have no locus standi to be implemented in the application as it's an unregistered society which cannot sue. Stop. Next, Moro, comma. The applicant has not made any statement as to why they should be impeded in the PIL filed by the petitioner. According to the copy for the applicant, pays for is granted a week's time to file the affidavit. Next paragraph, based on the affidavit shall be filed by 22nd Monday, 22 6 2026, based on 24 6 2026.
Well,
Listing date for that, 24.
20.
ठीक है सर. Mr. Just write it down. Write it down.
Item 42.
Yes, this is an application by the state.
Item 42.
Non-application filed for the applicant. Despite order dated 11/3/2026. As per office note dated 23/4/2026 and 34/2026, no steps has been received by the section for issuance of notice on the respondents. Accordingly, it appears that the applicants not interested to pursue the matter. Accordingly, the application is just wait, say, dismiss from, but just wait till 4:30. If they come, then we'll pick it up. Otherwise, whatever dismissal of, I will stand.
Upgraded item 46.
May it please your lordship, this I is filed under rule order 3, rule 4(2), for changing of advocate. The petitioner is unable to contact the advocate, and the advocate is not appearing for last 2 days. So
For that, you don't need an application, it's just to file a wakalatama.
but according to order 3, rule 4, the discretion of the court is required.
Which provision is there? We are unable to find out. In order 3 rule 4, where is that provision?
It's on page 125. Page 125.
See the provision, we have a different book. Which provision?
This order 3 rule 4
Yes.
sub rule 2.
Please read.
Every such appointment shall be in bracket filed in court and shall for the purposes of sub rule 1 be deemed to be in force until determined with the leave of the court by a writing signed by the client or the pleader. That part.
Your name?
S.A. Wasi. In the cause list, it is wrongly written as subversion.
Mr. S.A. Vasi will talk for the applicant and also for the respondent. This interrogatory application has been filed to bring the wakatum of the newly engaged counsel on the call. Application is allowed, matter. And disposed of. Next part, the registry shall reflect the name of the current counsel, whose name appear in the Vakaratama appended to this interrogatory application as counsel for the petitioner in WBC 3953 of 2019, and the matter is 19. In view of the order passed today in the connected IA Civil 1921 of 2026. Registry shall reflect the name of the new set of counsel who is Vakaratama appear in the state interrogatory application. Next para. This was your data publication.
Much obliged.
24 July.
Yes, Mr. Katunia.
In respect to item number 42, Malab, I was not aware of that, Malab, it's been taken up.
Yes, you have not taken steps, we'll have to
Yes.
discuss your application.
I have seen, Malab, there was some development in the department, Malab. They were supposed to withdraw the appeal due to some subsequent development. But now they have again decided to proceed with the appeal, Malab. So, Malab may give me 1 day time so that I can take the steps, Malab. Because one cabinet decision was taken to relax the rule for a time being, Malab, and that was taken, but it is for a particular dispute, Malab.
Mr. Angel Katunia will come for the applicant. Applicants. Wait for days time to take steps for service of notice on the respondents. here is allowed. The applicant shall take steps without fail to waste time. Next, notice is made available on so and so. Petitioner shall take steps for service of notice from the respondent by Speed post with AD. In addition, the notice shall be served on the respondents to the same by routing the process to the registry of the court and upon service, and affidavit of service shall be filed prior to the magistrate of visiting. Next, in the meantime, the counsel for the applicants is at liberty to collect the post petition number and to submit postal rack report prior to magistrate of visiting. Next, response. By which time?
Oblige ଅଛି।
For admission, item 21.
May please, sir. If I please for adjourn discussion. As a representative on the prayer made by Gauhati representative. Questions in one prayer, list on 8 after the picture.
Item 22.
Yes,
My lord, in this matter has come up in the admission column. Record is also available.
so this is an admission column only.
My lord. Admission column. But so may dispose of the admission column or may fix in the hearing column.
It depends on you. We are ready.
My lord.
If you are ready, we are also ready.
My lord, here I have seen the records also.
Yes.
The input order, the tribunal has not discussed the evidence of the petitioner as DW1. Documents has been discussed, but evidence oral or receipt has not been discussed. This is one of the defect in the case, and there are some preliminary objection to the proceeding. His father's name is his elder brother's name has been shown as a father of the proceeding in the inquiry proceeding. In the notice also, his father's name has been wrongly shown as Asmat Ali, but Asmat Ali is the petitioner's elder brother. And the inquiry report, kindly have a look at, my lord. This is a LEO report. The ERO has submitted the reference based on LBO report. LBO report is blank, except mentioning the name and in column 1 name. Lords, you will find in the annexure 3 of the petition. page 26. Twenty-six to 29, the LVU report, entirely blank except mentioning his name, Atem Ali, shown as son of Asmat Ali, whereas Asmat Ali is the elder brother of the petitioner. And in column 16 is totally blank, without any indication which category of charge. Period of entry has not been shown. Linkage to properly document. In the notice, my lord, mentioned two charts, 1166 to 66 and 24th March 1971 and 471. Both the charges are mentioned in the notice. My lord, page 31 up to page 36 is the WS. In WS, my lord, he has made a specific plea that D mark has been put against his name in the voter list of 1997, and that was been done behind him without any proper notice or without proper investigation. In para 3, 4, and 7 also, in the para 7 also, the report by the annexary of the LBO is not met as per guideline of the Election Commission of India. And para 10, my lord, he has made specifically that his father's name has been wrongly shown as Asmat Ali in the LBO report or notice. His father's name is not Asmat Ali. Asmat Ali is his elder brother. In para 11, he has mentioned that he is born on 1/10/1968, and father's name and mother's name has been stated in paragraph 12. Father's name is Umed Ali, mother's name is Ruhimanasa alias Sohran Nessa. So Ruhimanasa and Sohran Nessa is one and the same person. Then my lord, in paragraph 14, 15, 16, my lord, regarding documents, entry of voter list of 1965 and 70 of his father, and 51 NRC legacy data also. Then land documents of parents in statement has been made in paragraph 16. Family details has been given in under paragraph 17. The brothers are the siblings of the petitioner is Asmat Ali, Hatem Ali. Hatem Ali is the proceedee. Asmat and Hasmat are the brothers. Then Yusuf Ali is also brother. Khutuja Khatun, Malikjan, they are the sisters. My lord, paragraph 19 is a made statement that the family has to face erosion of Brahmaputra river. 90 paragraph 20, my lord, the mark against his name in the voter list of 1997. This is the all about my lord WS. Then my lord documents from page 37 onwards. 38 is the photocopy of the NRC details. Others name Umed Ali. Then voter list of 1965. Father Umed Ali, mother Suhran Nessa. Village Sonari Gaon. Then my lord 70 also. In 1985 voter list.
What about 1965 voters list? His father is there.
Father against his name, father is there.
Umaid Ali.
Umed Ali. Father's name appearing in the voter list of 65 and 70.
65 Umaid Ali is the father.
Yes, Umed Ali is the father. Umed Ali is son of Babuzan. Babuzan is the grandfather. Suhran Nessa is mother. 65 voter list. Then 70 voter list. Father's name Umed Ali, son of Babuzan.
These people, Usman, Suleiman, Khalid. Uncle.
My lord, they are near relative, but Usman Ali is not shown as son of Babuzan. Near relative, my lord, may not be of same family, but under same house number. Umed Ali is the father, Suhran Nessa is mother. In my lord, 97 voter list, his elder brother Asmat Ali is voter with the petitioner Hatem Ali, but Asmat Ali has been wrongly shown as his father. Asmat Ali, Hatem Ali, both are son of Umed Ali. And the tribunal has not make it correct, has not made any correction. But tribunal in the impugned judgment shown as son of Asmat Ali. In the LBO report notice, his father's name is shown as Asmat Ali. And there are 90 other voter list, 2019 voter list. Page 49, my lord, there is a Jamandi copy in the name of his father, Umed Ali. Umed Ali at serial number 3, Umed Ali son of Babujan. But as per his contention, the land has been eroded by the erosion of the Brahmaputra. And after erosion, they had to stay on the embankment.
From 97 onwards, these are now 35 properties.
My lord, after 97 voter list, my lord, 2019 voter list has been shown vernacular voter list. Certified copy cannot be, my lord. Certified copy is not giving because there is D mark against his name. In 97, D is in mark against his name, his elder brother's name, and therefore certificate copy is not given. My lord, he has also exhibited PAN card. Then, my lord, evidence in sheep at page 53 onwards, he exhibited PAN card, legacy data of 1951, voter list of 1965 and 70, exhibits C1 and C2, my lord, draft sheet and Jawaundi in the father's name, exhibit D, voter list of 1985. These are the documents he has exhibited. My lord, in oral evidence, he claimed that he read in a school, but no school certificate has been produced. My lord, his oral evidence is at page, translated portion at page 57, vernacular at 57A. May I read, my lord, oral evidence?
Yes.
My lord, in oral evidence, page 57, translated portion, my lord. I was born in the year 1968. I was born at village Sonarigao under the district of Morigao. I studied up to class 4. My school name was Good School and situated at Dakarmari Gao. I could not remember when I left the school. And my father is dead. He died about 12-13 years back. I could not remember the year. My mother name is Souron Nessa. My mother died a few days after my father's death. My father married one woman. My father had 6 children, including me. They are Asmat Ali, Hatem Ali, Opi, Isab Ali, Khudeja Khatun, Manik Jan. My 2 elder brothers died. Younger brother Isab Ali resides in Goram Bazar of Lahorigarh. I could not remember when I cast vote for the first time. I am presently residing at Sonarigao village. My father had landed property prior to 1971. which I have submitted in this case. I could not inherit my father's property due to river erosion. Due to river erosion, the residents of Sonarigao, including me, are living at Mathauri embankment of Sonarigao. Since about 10 years, I am living at Mathauri. Sonarigao has been eroded about 30 years ago. Well, he has given details of family. His Asmat Ali is his brother, elder brother, not father. But tribunal has not make it correct. And my lord, his oral evidence is also not discussed. Documents has been discussed, but his oral evidence has not been discussed in the impugned order. Impugned order is at page 58 onwards.
If cross-examination was discussed,
Well,
cross-examination was discussed,
my lord,
page 59.
yeah, the OP has stated his age as 52 years in his cross-examination on 2/3/2020. Was born sometime in the end. Yes, my lord, there is discussion.
You're relying on the case laws, Mr. Siddhar?
My lord, I am relying on the case of Rofika Bibi case, my lord. Rofika Bibi and Sonaka case. In the Rofika Bibi, this honorable court has discussed the judgment of full bench as well as the Supreme Court judgment, my lord. Copy kita sama. Didi nahi. WBC, my lord, 3330/2020. My lord, I have only 2 copies. My lord, paragraph 31, 32, 33. Rofika Bibi. It was not reported WBC number 3330/2020. My lord, this 2 copy I can. Yeah, 31, 30 onwards, my lord. Itu copy nahi hai, my lord. Number 2 was 3330 oblique. 2030 oblique. सामाजिक खर्चे नहीं है 2020 26 26 5 25 25. My lord, the impugned order and the notice, all everything, my lord, goes to show that there was neither a fair investigation. Mechanically the reference was made based on LBO report. LBO report was not proper. Father's name is wrongly shown. The petition at least could have shown that his father's name is not Asmat Ali. Asmat Ali is his elder brother. Petitioner is voter with his elder brother. So this goes to show that the reference was made mechanically, and mechanical reference is not maintainable in the light of the Prohibitions case and the full bench judgment, my lord. Then, my lord, I have to rely on the judgment of the Sunakha, alias Sunakhan, reported as 2021 3GLT, page 12. My lord, here I am relying paragraph 9 and 10. Charge should be specific. The allegation should be specific. Here the notice there is 2 charges. That means there was no investigation. Mechanically the reference was made and no inquiry. And therefore there cannot be 2 charges. When there is 2 charges, that means there was no specific investigation, no specific my lord, reference. So in the light of the Sunakha case, this type of reference is not maintainable.
But Asmat Ali is known as Umaid Ali, alias Umaid Ali.
No.
If you see the opinion at page number 62.
That has been wrongly, on what basis? On what basis they are saying? It was my specific contention that Asmat Ali is my elder brother. I am also voter with my elder brother. How the tribunal can say like that? There should be some material. Entire system, my lord, this is the system has been developed this way to discard citizenship of people. Only poor and humble people, they are victim of this system. This should be, my lord, rectified. The tribunal cannot do it. When there is specific plea with documents that my father is not Asmat Ali, my father is Umaid Ali, even though the tribunal has not made it correct. My lord, in the last paragraph of the opinion, under such circumstances, I see that the OP Hatem Ali, son of Asmat Ali, alias Umaid Ali, has miserably failed. How Asmat Ali can be Umaid Ali? This is the major mistake in the impugned order. So, my lord, my citation, my submission is based on, my lord, Sunakha alias Sunakhan reported as 2021 3GLT, page 12, and paragraph 9 and 12, we are relying on. 9 and 10 paragraph. Nine, my lord, may I read, my lord? Having heard the learned counsel for the parties also considering the material available on record, we are of the view that reference made by the Superintendent of Police Border Baksha cannot be said to be proper reference, since there is already a direction of this court that reference be made in accordance with law. We will not enter into this issue as to whether any reference could have been made at all in respect of the petitioner on the basis of the investigation so made, which has been reflected in the letter of reference dated so and so. However, we are of the view that the referral authority must make a specific reference to the tribunal for his opinion as to the period during which the petitioner allegedly entered into India, which is not discernible from the referral letter dated 18/9/2019. In absence of any such specific reference being made by the Superintendent of Police Border Baksha, obviously the tribunal will not be able to understand as to the nature of the reference. Accordingly, we direct the Superintendent of Police Border Baksha to make a specific reference on the basis of documents available within him, including the inquiry report, as well as the documents submitted by the petition as to during which period the reference has to be made vis-a-vis the petitioner. We are of the view that the referral authority cannot make a reference merely to ascertain as to whether a person is a foreigner or not, without making any specific reference of a period which has a basis in terms of Section 6A of the Citizenship Act 1955. It may also be noted that tribunal also cannot give any opinion beyond the reference as already held by this court in the case of Santosh Das Supra. Thereby meaning that there has to be a specific reference as regards the period of alleged entry in the case of doubtful illegal. The tribunal has here in this case shown two periods within this team and post team. So this is my submission.
Regarding EROs and very lottery, these so many times discussed by different articles in many occasions talked. And one lordship reported the judgment 2025 to 1058. Regarding EROs inquiry lordship, in so many cases, lordship, these issues was argument was held lordship in this issue, and lordship, this issue was settled lordship. In 2025 to GLT 1058, elaborate discussions was made by 2 GLT 1058. By upholding the decisions of earlier Samuddin's case lordship. And again, lordship, recently, lordship, this issue was again upheld by this honorable court in WPC 7764 of 2019, decided on 27/5/2026. So, lordship may. And regarding the mentioned in the notice, lordship, this issue was also discussed in this opinion, lordship. This opinion, and lordship, again I am submitting, lordship, and on earlier occasion, lordship, this issue was again settled by this honorable court in 2017 to GLT 996. Anando Ghosh versus Union of India, wrong mentioning of the stream
Ananda Ghosh, ANANDA versus Union of India, 2017 2 GLT 996. Proposition
The earlier one, what you said, 5 GLT.
1058. And connected WBC number is 245 of 2019. Tukurjan Nesa. Yes, Lordship. And Lordship, regarding wrong mentioning of the stream of foreigners in the notice. One connected WBC number is 245 2019. Lordship, WBC number is 245 of 2019. Lordship. Lordship, WPC 7764 of 2019. Hyla Khatun, BHAILA KHATUN. AILA KHATUN alias Rayla RAYELA KHATUN.
These are on references. These are on references.
Lordship,
These are on references made into these judgments.
regarding ERO inquiry.
EROs.
ERO inquiry.
My lord, these judgments, my friend is referring there, these are, my lord, coordinate division bench judgment. My humble prayer is that the full bench judgment is to be considered. Muslim model. And any judgment without, my lord, following the full bench judgment is not correct.
Lordship, full bench judgment is totally silent in respect of ERO's inquiry, Lordship. And all these things are discussed, Lordship, in Samuddin's case.
Which case is that? Samuddin, what did you say?
Samuddin, Lordship, regarding ERO's inquiry, Lordship, I will provide, Lordship. WBC 91 of 2019. And it was again upheld by read appeal number. Lordship. This is 91 of 2019, Lordship.
Sayuddin, WPC,
Syamuddin, what did you say?
SAYAM, Sayuddin, UDDIN. Number These things are discussed in Sukurjan Nesa's case, Lordship. Sayuddin's case has been discussed, Lordship. WPC 245 of 2019. And Lordship, may I submit, Lordship? And regarding wrong mentioning of the stream, Lordship, I have submitted 2017 to GLT 996. Ananda Ghosh versus Union of India. 2699 2017 to GLT 996. Paragraph 13, Lordship. Having, after discussion, Lordship, having regard to the above, we have no hesitation to hold that when the reference as to whether the petitioner was a foreigner belonging to post 71 stream, non-mentioning of the same or wrong mentioning of the stream of foreigners to which the petitioners belongs to the notices would not vitiate the ultimate conclusion reached by the tribunal that petitioner was a foreigner of post 71 stream. Since the reference was answered in favor of the state, it ought to be and has rightly been answered in the above manner. As a matter of fact, this issue was not even raised by the petitioner in his written statement, possibly because he was fully aware that the allegation against him was of being a foreigner belonging to post 71 stream. Therefore, this ground urged on behalf of the petitioner stands rejected.
But in our case, my lord, the WS, this has been, wrong mention has been mentioned. My
Lordship, regarding law point, Lordship, I have submitted, and Lordship, if we see the WS, Lordship, WS is totally fake, Lordship. Lordship, some vital things are not here in the WS, Lordship, particularly in respect of his parents' death. When his parents died, Lordship, this and Lordship, in a place of birth was not mentioned, and Lordship, in paragraph 11 of the WS, he categorically mentioned that the answering proceeding was born on 1/10/1968 as per his PAN card issued by the department. So, Lordship, if he is born in the 1/10/1968, how he can vote in the year of 1985, Lordship? he relied on the voter list of 1985, Lordship. Here, his name first time appeared Hatem Ali, aged about 27 years. If he is 27 years in the year of 1985, page 43, his date of birth would be 1958, not 68, Lordship. And if he is born 1/10/1968, para 11 of the WS. Lordship, here Hatem Ali. In 1985, yes, Lordship, he obtained his first voting right in the year of 1989. But 1989 voter list is not here, Lordship. He is not relied 1989 voter list. And Lordship, after 1970, what happened to his parents and other family members? These are not mentioned, Lordship. There is a huge gap up to 1985, 1970 to 1985. That continuity should be there, Lordship, but it is not there in the present petitioner's case, Lordship. After that, Lordship, only linked document is 1985 voter list and nothing else, Lordship. No, 1985 voter list, he was not shown as D, Lordship. In 1997, he was shown as D, and I think, Lordship, that voter list is NX, Lordship. It is not a certified copy, Lordship, I think, Lordship. 1997 voter list is not certified copy. Although in his evidence, Lordship, he stated that, Lordship, he read in a school, Lordship, but that school certificate is not here, which is a most vital document to prove one's citizenship, Lordship. And Lordship, only voter list is here, and voter list is not sufficient, Lordship. In this regard, what Ajit Mia's case says, Lordship, I am just relying para 14 of the Ajit Mia's case, 2023 4 GLT 246. Connected WPC number is 2370 of 2023. 2023 4 GLT 246. Lordship, WPC number is 2370 of 2023. Aziz Mia, AZIZ MIYA, alias Muhammad MD Aziz Mia, AZIZ MIA, and decided on 9/6/2023. Para 14, Lordship, I am reading para 14. We are constrained to observe that mere claim by a suspected person by referring to a voter's list, claiming a person therein to be his father is not a conclusive proof, and that by doing so, the person has discharged the burden that he is not a foreigner. This is because there is also further requirement to prove that the person who is reflected in the voter's list relied upon this actually the father of the person who makes the claim. The claim will have to be substantiated with further materials acceptable in law. So, Lordship, proceed is lack of such further materials by which, or Lordship, further documents by which he can link with his projected father, whose name reflected in the voter list of 1966, Lordship. So, Lordship, my humble submission is that, Lordship, I think there is no infirmity done by the tribunal, Lordship, in passing the opinion, Lordship. So, opinion may not be disturbed, Lordship.
My lord, so far the claim of the petitioner, my lord, the full bench has said in paragraph 117.3, if the state did not challenge the version or claim, then, my lord, during the cross-examination, the said version of the appellant remains unrebutted. Here in this case, my lord, the petitioner, by relying on the voter list of 1965-70 and listing his parents' name, he has claimed that I am the son of Umed Ali. So, my lord, that claim is remained unrebutted because there was no cross-examination. This is my one point, my lord. And this is a full bench judgment. You have to follow the full bench judgment. Coordinate bench judgment cannot supersede the opinion of this full bench judgment. This is the one point, my lord. And so far the statement regarding the name, there is a regarding the proceeding, how the proceeding has been framed. There in the WS, my lord, there is a specific claim that his father's name is Asmat. His father's name is not Asmat Ali. Asmat Ali is his elder brother, and father's name is Umed Ali. In paragraph 12, in WS has been mentioned, and in paragraph 17, he has given the name of siblings. Asmat Ali is one of his siblings. How the tribunal can retain the reference and the relation that Asmat Ali can be alias Umed Ali. That is absolutely wrong. Yes, one may be declared foreigner, but how this way the identity of a person can be declared in this way? This is the wrong, absolutely wrong judgment of the tribunal. Lordship may interfere into that action also. With this, my lord, I am concluding my submission.
Petitioner also had some of the response.
Item 23 for admission.
May I please, Your Lordship? Lord, may I pray for adjournment of this matter today, madam? May I pray for adjournment of this matter?
Obliged, ma'am.
For admission, item 25.
I will health department file affidavit, everybody is there. Lots is directed to file affidavit to health department earlier. Health department file and last post-mortem report also is there. Ma'am. Report post-mortem annexure A, page 22.
My lord, against the affidavit in opposition, the petitioner has filed affidavit in reply, my lord. And she has not accept the affidavit in opposition, the opinion of the doctor, my lord. As the opinion of doctor says that there is no any poison, my lord. And while we go through the postmortem report, my lord, opinion of the doctor and the postmortem report are not corroborated, my lord. Are not totally, my lord. Your lordship kindly see.
Right lung. Right lung is, so first you come to the thorax, you see walls, ribs and cartilage healthy, pleurae,
Yes.
congested and adherent to inner chest wall and lungs. You know the meaning of this? Do you understand the meaning of this postmortem report? Congested and adherent to inner chest wall and lungs?
My lord, but there is no specifically
Please
lung
answer
disease, my
me.
lord.
Do you know or you do not know?
My lord, I do not know what is meaning
Then I'll
there.
tell you. If you are referring to this congested and adherent to inner chest wall, that means a lung, when it is not functioning well, it will catch the what you call it will wrap up the inner lung area and will attach to it. Therefore, what happens is that if the lungs are attached, then you can't inhale. There is a chest congestion, you can't inhale. So the what you call the congested and adherent. Adherent means it is sticky. It sticks to the wall. The liver will have the chest. After the chest tube will be the liver. Chest wall. Chest wall will be of two lining. So once they get attached, then in the next you will find right lung, both lung congested and adherent to pleura. So that means it is sticking up together. It can't expand. On dissection, fibrosis and consolidation found at lower. So fibrosis means that the fibrosis is there, therefore the lung expansion has stopped. It is having a what you call condition of fibrosis, and then found in lower lobes with prudent discharge from the margin. So therefore, where there was a cut to that chest, then from there was a prudent discharge. That means there was liquid inside. It can be mucus, it can be anything, but there is mucus inside. That means the lung, so far as it's concerned, lung is choked because of the pleura inside, and he can't breathe. This is what it means. Pericardium is congested. So again, there is congestion there also. Heart congested and chambers contain liquid and clotted blood. Therefore, when you read to congested and adherent to inner chest wall, it all leads to a conclusion that the chest condition is not good. The lung condition is not good.
My lord, if the petitioner's husband is suffering such type of disease, but he was not taken treatment, my lord. It is not a one-day disease, my lord. He is suffering.
We don't know. I am not a medical expert, but we are trying to read from this whether he died because of the police brutality. No, there's no police brutality. There may be a delay in the taking up of the person for treatment.
At the last moment, he was sent to GMCH, my lord, and within half an hour, he confronted death, my lord. That is the negligence of the part of the medical unit, my lord, in the jail authority.
Can be possible. A very healthy man can drop dead immediately.
Yes. Organs of the generation, external, internal, are shown as a healthy, my lord.
Pardon me?
In abdomen, your lordship kindly see abdomen, postmortem report in serial number 11, organs of generation, external and internal, healthy.
The abdomen has nothing to do with chest. wall is healthy, peritoneum is healthy, mouth, pharynx and esophagus, again, wherever there is a chance of congestion, mouth, pharynx and esophagus, you both are congested. That is some sort of problem is there with the person. He's got chest congestion.
My lord,
Stomach, intestine, you omit, liver omit, spleen omit, kidneys, bladder, organs of generation.
my lord, another point is that nota vena, observe the state of all the organs, and when no disease injury is found, write healthy. In page number 12, my lord, postmortem report, nota vena, observe the state of all the organs, and when no disease injury is found, write healthy. That is the medical report, my lord.
Correct.
If,
Correct. It is not your case.
if no injury, no disease is found, then they write healthy. If there is an injury, if there is a disease, my lord, that must be reflected, my lord, in the postmortem report. Or I do not know, he may be suffering from such type of injury, disease, my lord, but he was very belatedly, very lately, he was sent to the GNC's hospital for treatment, my lord, just after half an hour, my lord, at the time of the moment of the death, my lord, that moment, my lord. That is-
I don't know. You see, I don't have any material to show that how much time a man will take from his diagnosis to be deceased till his death. Don't know about that.
And the picture also shown when the husband is was struck by the wife, my lord, at the hospital, and very tragic condition was described by the petitioner, my lord, in this petition, my lord. Police personnel threatened the petitioner's husband. He was not allowed to go to the latrine, my lord. He wanted to say something, but he was prevented from, he could not speak anything, my lord. He was not able to stand, my lord. He
Prevented, he could not speak.
yes, my lord, he could not speak anything, my lord.
You had
And
also visited him in the jail
And-
and you did not find any.
and he was not allowed to go to the latrine, my lord. His physical appearance is so dirty and so it cannot be described, my lord.
But in the postmortem, the lungs issues are there, are reflected. And you had gone to visit him, that time he had no ailment. It can happen suddenly.
And my lord, the petitioners thereafter so many miserable conditions, my lord. After the death of her husband, father-in-law is expired, and after a few months, her son is also expired, and her daughter is confronting mental and mental condition, my lord, as she was defamed, my lord, in society, my lord. The father was arrested due to misbehave.
It was P.R. Sultana, learned legal aid counsel for the petitioner. And Mr. P. Sharma, learned additional senior government advocate for the respondents. Matter has been heard on then. So for further hearing, list again on. Take it Friday.
19.
Muscle.
That's- It's people for the Friday as well. It's people for the people. Increase. Right? Thank you.